Hey everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York, and in this video I'm going to go over a scenario that, to be frank with you guys, actually occurs with alarming frequency, I think, in California divorce cases. The scenario relates to community property. So for those of you who, I guess, don't know what community property is, or maybe you live in a state that doesn't use it, let me kind of give you some background. So whenever a couple divorces, whenever they split up, for example, they inevitably have stuff that needs to get divided. It might be a house, let's say. It might be furniture, bank accounts, 401ks. It could be debt, medical debt, credit card debt, etc. So each state basically has ways to divide stuff like that when a couple is divorcing. The way that California does it is via a scheme called community property. So think of it like three buckets, I guess. So bucket number one is going to be all the stuff that spouse number one, let's suppose spouse number one is the husband. It's going to be all the stuff that husband owned from before the marriage, all the stuff that he acquired during the marriage via gift or inheritance, let's say. All of that stuff is going to be his separate property. That's going to be in this first bucket over here. If you understand that, hopefully you can take that same idea and apply it to spouse number two. Let's say spouse number two is the wife. So you're going to have all of wife's separate property in bucket number two right here. And all the stuff, probably basically all the other stuff that's not in either of these two buckets, is going to be community property. That's the stuff that the couple has acquired together while they were married. All of that is going to be in bucket number three over here. So the way that it basically is done in California is that everything in this community property bucket has to get divided basically 50-50. So yeah, I guess so that's the basic sort of idea. And the scenario that I encounter a lot is basically this. Let's say that during the marriage that, the couple acquires something pretty big. So let's say it's a house, or let's say that spouse number one works for a software company. He gets a bunch of stock while he works for the company goes public. So this stock suddenly overnight went from, basically worth nothing, to worth, say, $15 million. And during the course of the divorce, spouse number one, the husband again in my scenario, husband number one might think, well, this house is mine. Like, I bought it. It's something where I'm paying the mortgage, from my salary. She doesn't work. I'm not going to give her this house. So tell you what, her name is on the deed, but I'm going to figure out a way to remove her name from the deed. I'm going to have her sign a quitclaim deed, let's say. And if I do that, the house will be adjusted in my name. I won't have to give it to her. I won't have to split her or give her any share, let's say. Aren't I so smart for thinking of that? And then for the stock also, you can probably imagine that he'll go like, okay, well, tell you what, I'm going to take all $15 million of stock right here. I'm going to put it into a brokerage account that just has my name on it. I'm going to put my name on all the documents related to this stock. Her name is not going to be on anything. Therefore, I won't have to share, $7.5 million possibly worth of stock with her. Aren't I so smart for thinking of that? And I guess, what's the polite way to put this? It does not work that way. So the short answer, that's basically the short answer. It does not work that way. It's like, I guess I'm struggling to find the right word here. Like, I've seen this scenario play out in court multiple times on other cases. I've had several cases where this scenario basically has played out also. And to say that it basically never works, I think would be an understatement. A lot of times in my cases when the other spouses try this, it crashes and burns in spectacular fashion. Like, this is such a basic thing that it's really not worth trying to kind of play games or tricks or trying to hide stuff. Community property basically will win out at the end of the day. So yeah, so let me get off my soapbox, I guess, and kind of give you the actual explanation. So the short version of the answer is that it does not work that way. Community property doesn't work that way. You can put this stock in an account that has just your name on it. It doesn't matter. Community property still applies. You can take her name off the deed to the house. Doesn't matter. Community property still applies. So that's the short answer. The longer answer, I guess, kind of involves the statutes, the cases, etc. So if I had to say it, I guess, I can sort of understand where the husband, I guess, in my scenario is coming from, like what his thought process is. why he would think that, oh, well, if I take her name off the deed to the house becomes mine. I can sort of understand, I guess, where that comes from. In general, for instance, if you're trying to find out, who owns a house, who owns a vehicle, I think a lot of us would basically look at the title documentation, be satisfied with it, and go like, yes, Andy Chen owns this house because his name is on the deed, for instance. And same thing for a car. Andy Chen's name is on the title. Nobody else's name is on the title, therefore this car belongs to Andy. So I think that kind of makes sense to a lot of people, kind of in general. In California, actually has a statute that sort of goes over what I just kind of described. It's California Evidence Code Section 662, which I'll write right here, as well as link down below for you in case you want to go look at it. But 662 basically says this: whenever you have a piece of property that you're trying to determine the ownership of, title documentation is going to be assumed to be correct. Other evidence can be introduced, so title documentation is not dispositive, but title documentation is where you're generally going to start. So that's sort of why I think husbands in my scenario sort of think that they can get away with a scheme like this. Community property, however, is an exception to 662. So 662 does not occur, it doesn't apply universally, absolutely everywhere. Community property is an exception to it, and the case that I learned this on is called Marriage of Decker, which I'll write over here, as well as write down below and put the site to it also. I haven't Google Scholared it or something like that, but I'm pretty sure you can find it on, for instance, Google Scholar. So Marriage of Decker basically, kind of, if I have to summarize it, basically says that, okay, well, 662 normally would apply. Normally you would rely on the deed to the house to figure out who owns it. You would rely on the pink slip to a car to figure out who owns it. If, however, there's community property that applies, community property will basically supersede. So the thing is, if there is a house and there's a divorce going on and, there's community property possibly at play here, you don't look at just 662. You might consider it, for instance. However, you're also going to look at other factors. For example, when was this house purchased? Was it purchased before the marriage or after the marriage? So the date is going to be really important. You're going to look at how the house was acquired. Was it by gift? Was it by inheritance, etc.? If you bought the house after the marriage, was the house actually purchased with funds that were from before the marriage? Let's say husband sold the house prior to marriage, held on to the money. After they married, the husband bought the house, paid for it himself. In that scenario, maybe the house is separate, even though it was acquired after the marriage actually happened. So, Marriage of Decker is not the the only case that goes over it. It's the case that I learned this on, and I know that a lot of judges that I've been in front of will rely on Decker, for instance. But there are other cases. I don't mean to say that Decker is the only one, but for better or worse, I guess, a lot of times in law, the name of the case where if the idea was first originated, or the case that was the most famous, one that actually discussed this, the name of that case is then attached to that concept for perpetuity. And in this case, Decker, I guess, seems to be the case where this idea was the name attaches to it. So hopefully all of that made sense. So I guess to kind of summarize for all of you, community property is really powerful in California. It applies to a lot of different property in a divorce. It applies in a variety of different ways. So normally, outside of a divorce context, let's say, you would normally rely on title, pink slip, deed, etc. You would rely on the names that are on those documents to determine who owns a piece of property or who doesn't own that property. However, if you have a divorce scenario, California divorce scenario, where community property possibly will be at play, on this house, let's say, community property, one spouse has a community property portion to it possibly, you are generally not going to rely on just 662, Evidence Code Section 662. You have to go in deeper to look at how was this property acquired, when was it acquired, how was it paid for, etc., etc. And only after doing that can you really determine, okay, even though this house was purchased after the marriage, it's still separate property for these reasons. Even though this vehicle, let's say, only has wife's name on it, husband still has a claim to it. Similarly for this stock was acquired during the marriage, and just because husband put it into an account in just his name, that doesn't change anything. Wife's community property interest is still there. So she's therefore still entitled to half of it or a third of it or something. So that's the basic idea. If you are thinking about trying to kind of cheat community property or to kind of go around community property's rules by just putting stuff in your own name, you can certainly try it. In my experience, I've never seen that work before. And it's actually quite hilarious when people try to do it. Like they go in there with a lot of confidence and they crash and burn spectacularly, I guess is what I'm trying to say. So yeah, I guess if you are the kind of wife in the scenario that I've sort of been using, like, you know, your soon-to-be ex-spouse is trying to cheat you out of community property, let's say, hopefully this video helps you. But yeah, I guess, you know, if you're trying to kind of play games like this, don't. Like, it doesn't work. Like, just save everybody the grief, the time, the effort, etc. Yeah. So anyway, hopefully all that made sense. You know, if you are in this scenario, you know, possibly, you know, trying to cheat your soon-to-be ex out of property, don't bother. If your soon-to-be ex is trying to cheat you out of property, hopefully this video kind of helps you and you can put a kibosh to all of that. Yeah. So anyway, again, hopefully all that helped, and go ahead and share, comment, like, subscribe, all that stuff. And I will talk to you guys next time. Thanks.